I wanted to give a quick overview of our agenda for today because it's a packed agenda and we look forward to having everybody here. I'm going to introduce this panel momentarily, our European Data Protection panel. Starting at noon, we have a wonderful national security panel. And the title of the panel is The Innovation Revolution, the Explosion of Personal Data in the Private Sector, and what does that mean for privacy and national security? That discussion is going to be moderated by Charlie Savage from the New York Times, a Pulitzer Prize winner who has been covering the space for quite some time. And we have Jeremy Bash, who's now from Beacon Global Strategies and was previously the Chief of Staff at CIA and the Department of Defense. In fact, he was Chief of Staff at CIA during the Osama bin Laden operation, just a real leader in the field, together with Glenn Gerstel, who was previously the General Counsel at NSA, and Bob Litt, who was previously the counsel at ODNI. Just a terrific panel on national security and privacy. We have a privacy leaders panel today at 1 o'clock Eastern with Ruby Zeffo from Uber, Mike McCullough from Macy's, Barb Lawler from Looker, all of them longtime experts in the field. We have our Ask an Expert panel starting at 2 o'clock. We have a 2:30 panel that's focused on technology. What does it mean to really automate? What does it really mean to bring these technologies to our community? A wonderful panel with T-Mobile, Deloitte and Touche, Big ID, and of course, Wirewheel. We have a privacy investors panel. So we have brought some of the leading venture capitalists who have been investing in privacy technologies to talk about how they see the space. Where are they seeing real innovation? And finally, we are very proud later on today to bookend our keynotes. We had Helen Dixon as our opening keynote talking about privacy and human rights from the global and the European perspective. And we're proud to have Jamie Raskin, who is a congressman from here in the United States, who he was a constitutional law professor before he became a congressman, a real rising star in Congress. He's been fighting for human rights and civil rights for his entire career. He's one of the sponsors of the civil rights privacy and police reform legislation that's moving through Congress. And he'll be talking about how to protect civil rights and human rights in a time of these times of crises, very much building on what we've had throughout the conference, including Helen's wonderful keynote yesterday. So we're delighted to have you all here today. I hope you will enjoy the rest of the program and you'll join some of the social events as well. And now I'm going to go ahead and introduce just a terrific panel and a discussion on European data protection. And I'll let Gabriela Zanfir Fortuna she's a senior fellow at the Future of Privacy Forum. Her regular blogs and writings on European data protection law, if you haven't seen them, you should subscribe. They're probably among the most followed, thoughtful, deep discussions on European privacy. And a lot of our community just looks to Gabriela for that sort of practical, but also global expertise. We have a wonderful panel. I'm going to turn it over to Gabriela for introductions, but on behalf of all of us at Wirewheel and the whole Spokes attendees, I want to thank each of you for donating your time to bring this terrific panel to life. Gabriela, over to you.
Thank you so much, Justin. Hello, everyone. Good morning and good afternoon if you're logging in from Europe or somewhere else in the world where it's not morning, like we have here in the US now. I'm so delighted to be here with you today and absolutely excited to have this panel. We have Helen Dixon this morning with us, who is the Data Protection Commissioner for Ireland, if she needed any sort of introduction, and the keynote speaker for Spokes from yesterday. We also have Bruno Gencarelli, who is the head of unit of the International Data Transfers Unit at the European Commission, and who worked tirelessly for the Privacy Shield in the past, but also has been working a lot on new agreements with third countries and assessments on adequacy, and has been having his hands full of all international data transfers assessments. And we also have Simon McDougall, who is the Executive Director for Technology and Innovation at the Information Commissioner's Office in the UK. Hello, everyone. Thank you for joining. We have a very, very ambitious topic for our panel today. And this is because we are supposed to cover three big issues. COVID and privacy, and we've already learned a lot during the panels of yesterday about what are the key issues in this area. But we will also talk about the GDPR, some GDPR updates, how is the GDPR working, how is it not working, and what's coming GDPR in the future. But then we will also look at one of the biggest decisions we're waiting for from the Court of Justice of the European Union in the Schrems II case, which is supposed to be published on July 17, if I'm not mistaken, or in any case, around that date. So there you go. We have a lot of topics, and I will start now with the COVID and privacy. We've heard that most of the problematic issues we've been talking about are contact tracing apps, thermal scanning, immunity passports. We hear from employers that they need to do something about having people coming back to work. And I'm wondering, Helen, I will direct this for you at the beginning. What are you hearing from the organizations that are in touch with you? And what are the key issues here? And I will also have a follow-up question on that, because I'm interested to know, where did you put any sort of limit in the sand? What do you think it's acceptable in terms of data practices and not acceptable?
Hey, thanks, Gabriella. We certainly are getting a lot of questions, obviously related to data processing in lots of different contexts around the pandemic. Questions from the public health authorities in some cases, questions, as you said, from employers, questions from affected individuals, data subjects themselves. So just to start off, maybe before I get into the snags and the questions and the imponderables, to say something positive, I think what's been really positive is to see that data protection and privacy are really central in any conversation now where we discuss measures and public health measures that may involve personal data processing. So I was interested to see that the World Health Organization and the European Centre for Disease Prevention and Control as examples, they mentioned mid-pandemic when they were talking about measures to contain the virus, need to always ensure that personal data was protected in terms of any measures. And I think to me that seems to be an acknowledgement that if you're going to get the public support for the level of curtailment of freedom that have been involved in most of our jurisdictions in order to contain the pandemic, you're not going to maintain that support of the public if you violate their trust in terms of their data rights. So I think that's been positive, because I'd seen a lot of early commentary concerning itself that this might be another 9/11 in terms of data surveillance measures that follow the crisis. And I think at the moment that comparison happily doesn't seem to stand up, but of course we need to be vigilant. So I think for us there's two challenges. Firstly, there's the issue of when we don't get the difficult questions asked of us in the first instance at all, and organizations move ahead taking actions without considering whether there might be a data protection implication. So for example, in Ireland, there was mass testing of employees and staff in certain workplace settings like healthcare settings and meat processing factories. And partly for expediency and efficiency reasons, the public health authorities decided they would communicate the test results to the employer and have the employer in the first instance communicate them to the employees. So we began to get immediate concerns expressed by employees. In one particular case, a person called us and she was particularly distressed because she was self-isolating at home as she needed to do because she had symptoms, and she had just received a call from her boss that morning with whom she had a somewhat fraught relationship, saying to her, well, you can end your holiday there now because you've tested negative. So probably an added annoyance to the data protection infringement that it was in communicating the results in the first instance to the employer and not to the individuals themselves. So little things like that, but with big impacts for individuals. We've also had a lot of questions arising now about a return to work protocol that the government in Ireland published. There wasn't consultation with my office in advance on it. It requires a lot of form filling in many different contexts, including a pre-return to work form that every employee has to fill out. And what's very unclear is what the connection between those measures that involve significant personal data processing is and stopping the spread of the virus. So we're in engagement now with the relevant government department to try and understand, are those measures legitimate in the first instance? And also temperature checking, I think you mentioned that, that's included in the proposed measures. But in fact, the starting point for any of these activities needs to be to establish, do they really serve a purpose, and the purpose that people think they might serve in terms of containing the virus or tracing? And then the personal data processing is likely incidental after that, if there is a legitimate purpose in the first instance. And with a lot of these measures also, there's a need to check around their legitimacy as to whether they comply with employment law, whether there's a basis under health and safety law for the employer to implement them in the first instance. So in many ways, I suppose what I'm saying is the data protection assessment isn't the first question, while it needs to be considered and needs to be in there. Actually, there needs to be a clarity in the first instance about the legitimacy of the measures and the compliance of the measures with other legislation. So in Ireland, we're fortunate we have a very prominent and forthright chief medical officer who's a very clear communicator with the public. And so he's been very clear about the need for an evidence base, which gives us a good starting point. So for example, he has publicly commented that temperature checking doesn't seem to be a useful way of containing or eliminating, because it's easy to circumvent temperature checking. So that's important to bear in mind for any organization implementing data processing off the back of temperature checking. Are they really sure it's going to serve a legitimate purpose? And then I think you briefly mentioned this idea of antibody or immunity passports. Again, there are issues around the reliability of the tests in the first instance. And then, of course, the scientists say that we don't know how long anyone would have immunity from reinfection from the virus for anyway. So again, you'd want to be very careful about proposing significant personal data processing and restriction on people's rights if there isn't an evidence base there in support of the measure. I could talk a little bit about contact tracing apps, but I'm conscious of time, and you may want to move on to other speakers, so you can direct back to me if you'd like me to talk a little bit about that.
Thank you so much for that overview. And I, as Justin was saying, I publish here and there, and one of the things that I published at the beginning of this pandemic was that, you know, data protection law has all the tools to allow us to fight whatever we can fight of the pandemic with data, as long as we do it responsibly. So I think what you've been talking about, what you've been answering, it really goes towards that line that yes, you know, we can use data processing, but as long as it's justified, as long as it has a specific purpose and you have all the safeguards put in place. Now I will turn to Simon, and we've been talking about the extrinsic if you want, challenges of the pandemic for a data protection authority. But how about the internal challenges of a pandemic, Simon? Because you know, data protection authorities are organizations as all of the other organizations out there, and there were obvious challenges to the daily work and the daily work stream. How has the ICO dealt with that? What decisions did you take to handle your caseload internally, and how is that working?
Thanks, Gabriella, and thanks to YWL for inviting me to this session. I mean, before I go on to this, I just want to comment on your last one, Gabriella, which Helen alluded to as well, which is, I think it's an excellent point. I think the GDPR has really risen to the occasion as a piece of regulation in this context. We've been asked many times in the UK whether aspects of the GDPR need to be amended or flexed or subject to emergency legislation in order to support efforts to respond to the pandemic. And you know, and our answer has been actually that the GDPR caters for these situations, and in particular in terms of public interest, public tasks, but through many aspects of the GDPR. You know, through the good work in drafting and structuring the regulation in the first place, we've found that it has all the tools we've needed in the UK to actually address what people are trying to do. So there hasn't been any attempt so far to, hasn't been any need so far to, you know, include any amendments to the regime in our emergency legislation. So completely agree that it's, I think, a credit to the GDPR 2 years on that we're in that situation. In terms of how the ICO reacted, well, we've gone through a few different phases. I mean, you know, internally, operationally, we were lucky. We kind of, most of our staff have mobile devices, and so the large majority of our 700 staff are able to work from home quite quickly and relatively easily. In the first few weeks of this phase of the crisis, we focused on posture, so making sure that we communicated to data controllers in the UK and to other stakeholders that we understood the needs of the pandemic, and we understood the need to exercise discretion as to what we prioritized. And then as we were doing that and communicating a regulatory posture, we undertook an internal project to reorganize ourselves to address the challenges of COVID. So we set up a separate unit which was dedicated solely to answering questions we had from stakeholders, and that has now dealt with over 500 individual cases, and that ranges everything from quite small cases where, let's say, a local authority is trying to answer a question around whether it can share information about vulnerable individuals with different parties, all the way through to the UK contact tracing scheme, which is obviously a very large project in itself. And so we've dealt with all the points that Helen mentioned there. There's points around working from home, there's points around return to work, there's points around temperature testing, there's points around immunity passports. And in some cases, we have been just responsive. In other areas, we've produced a whole range of guidance on a microsite, including Q&A. With contact tracing itself, which we may all come back to, I imagine, we produced a blog at the time, but we also produced a formal opinion on the Apple-Google API specifically, talking around our thoughts on that contribution to the debate, and in doing so, a contribution to the discussion around centralized versus decentralized architectures there. And so we've got a bit of a body of work coming on. We have a separate team at the ICO that is focused primarily on what the new normal will look like. So what the world looks like in the future. That's provided a range of benefits to us. They were doing work on immunity passports before that was an issue. One of the small silver linings to the COVID cloud is that the whole world is going through this crisis at the same time. And that means we can look around the world and see which countries have already encountered a challenge and what they have learned from it. And so, you know, we should be able to actually learn from that and pick up what the future trends are, such as with immunity passports. I would say that we're very focused in that future-facing work on how we navigate back to whatever normality looks like over the next few years, accepting it's not going to be the same as the old world. There are some particular points there which are relevant maybe more to the UK than elsewhere, but maybe they are. I think we have accelerated how we innovate and share around health data in the UK rapidly in the last couple of months. And there's no desire to go back to some of the old ways of working where we have actually enhanced the way we share data between the different parts of the UK NHS. There's some problems people have been trying to solve for a long time, which have been solved through necessity, and we need to make sure we retain the value from that health data sharing in the new world. And at the same time, we are also focused on some of the challenges of both return to work and return to a functioning society, and what that means, and trying to think ahead for whether some of the measures which are currently voluntary in many countries get pushed towards the mandatory if they don't work. And I think there is a knotty question we need to think through here in terms of the end game with COVID, which ties into public interest. So we have a point around public interest where I think the public interest test has been used flexibly and productively in many countries with strong privacy regimes. But in the UK, we've started to realise that a lot of the public interest discussions then tie into the efficacy, the effectiveness of different COVID techniques. And Helen touched on this with regards to temperature testing. If we're saying as a regulator, well, something is in the public interest, we are making an assessment of a balance. We're making an assessment of the balance between some level of privacy intrusion upon individuals and the overall interests to society at large around a particular measure. If a particular measure isn't effective, then the public interest test is unlikely to be met. So we end up getting dragged as data protection specialists into questions around whether a particular measure is effective, and suddenly we are becoming experts unwillingly in epidemiology or in the mechanics of temperature testing and in what temperature thresholds are relevant for COVID versus other viruses, etc. And obviously we shouldn't be experts in that ourselves. We should try and find the right sources elsewhere for that. But as Helen alluded to with her experts in Ireland, we need to find the right experts, because very often these are very live debates and different experts have different opinions. So we are finding as we move through these public interest questions, we need to work out what's going on. With temperature testing of, say, public spaces, for instance, we're still struggling to find an authoritative voice that actually says that those techniques work. We're getting asked these questions a lot, and we're not necessarily seeing a compelling argument for temperature testing at this point in time. I think this is going to become an increasingly pressing question, Gabriella, as we move towards the new normal, because if people start to get eager to move out of lockdown, out of the movement restrictions they have in whichever country they're in, they're going to be pushing to have their freedoms restored. And we're going to be pushed as to whether we think something is proportionate or not. So some of these points become more and more critical, and whether something actually works or not is going to become critical there. So we're not out of the woods yet, and I think we're going to have to keep coming back to this and working as a community of regulators to compare notes and make sure that we have an understanding of what is effective or not.
Thank you so much, Simon. And absolutely, as Helen mentioned yesterday, how the GDPR kind of became the law of everything. I'm not convinced that's actually a bad thing. And I think this is something that drew me to data protection 10 years ago, because I thought it's absolutely fascinating how the former directive was touching absolutely everything around what I was studying in law school, but nobody was paying attention to the data protection directive back then. So you are absolutely right. I think there's a lot of knowledge pressure that's put on data protection specialists, and particularly during these stressful times. I will turn to Bruno now, and I will just say that the European Commission has been there on the front line from the beginning of the pandemic with issuing guidance, you know, convening special public health specialists to come up with a toolbox for contact tracing apps. And there has been so much work done in this space that's available out there and that has served as guidance. But because we have to tackle so many other topics, I will actually pick the point that Simon mentioned earlier that, you know, maybe GDPR did rise to the occasion this time because, you know, it allows the tools, it gives us the tools to use data and be effective in the pandemic. So I will turn the discussion to GDPR and ask Bruno about the upcoming evaluation of the GDPR that the Commission has to publish. I think it's actually a legal mandate, right, Bruno? And maybe tell us a bit about this mechanism. Why does the Commission have to publish these reviews of legislation? And then where are we with the review? Can you give us some insights?
Yes, and first of all, good morning or good afternoon or good evening, depending on your time zone. The report will be adopted by the Commission next week on the 24th of June. I understand that there will be also a report adopted in the same week in Ireland on the impact, the evaluation of the GDPR from Ellen's point of view. Actually, I have the report with me. Sorry, this is special for your viewers, for your audience. You are the first one in the world to see it. But of course, it's not yet adopted, so I cannot really speak about it. But why a report and what this report will look at? Why a report? Because this is not about, sorry, some of you might be disappointed. This is not about proposing a new GDPR or amending the GDPR. Actually, from all across stakeholders, even if this would have been the intention, the message was 2 years, a very, very short period of time. We want to have a stable legal framework, and we don't want this to change. The fact of having common rules of the game, baseline legislation is extremely important. So this is not about the review of the GDPR, but it's about the evaluation of the GDPR. And why was that put? Indeed, you're right, Gabriela. This is a requirement which is set in the GDPR itself in one of the last articles that maybe we sometimes forget to read because they are at the very end, Article 97. Because when the GDPR was discussed, at that time I was leading the delegation who was negotiating it with the co-legislator, the European Parliament and our member states, the Council. It was decided that on certain aspects that were very new, because as you know, the GDPR builds upon a previous legislative framework, but things that were very new, certain choices were made, but there was a feeling that sense that, you know, we would need to go back to that quite quickly to see whether the right choices were made or whether some adaptations would be needed. And this was essentially on one aspect, which is the governance and the enforcement structure system. As you know, we moved to a structure which is at the same time decentralized, relies on national data protection authorities, but with new responsibilities, including for the lead authority, which is often the Irish authority, and a new body with legal personality and binding powers, which is called the European Data Protection Board. So all of this was new and was also quite different than what was proposed initially. So that's why the GDPR identifies this issue as one that the functioning of which needed to be evaluated. But we have decided, after having heard stakeholders, consulted broadly stakeholders online in meetings, in a stakeholder group, after having heard and listened to the DPAs themselves, the EDPB made a submission to this for this process, having heard the member states, having heard the European Parliament, to take a much broader approach, to issue a number of issues, to address, a number of issues which have been raised during the past 2 years. And so this is about essentially evaluating the application of the GDPR, what it has meant, what it means for the actors involved, citizens when they exercise their rights, companies, businesses, of course, including small and medium companies. What does it mean, the application of the GDPR to new technologies, some of which were actually not there when we negotiated the GDPR. What does it mean also? What does the GDPR has brought in terms of indeed a new functioning of the enforcement and governance system of data protection in Europe? I'm not going to go in the details, but what has a clear GDPR have been met many of the expectations, but that doesn't mean, of course, that there's not work to be done or unfinished work. So the report will also identify clearly a number of areas for future improvements. With also, I think, an idea of realization that 2 years is really quite premature on some of these issues that are very complex to draw any definite conclusion. An aspect also I should have mentioned is that we are of course also addressing the international aspects because privacy play an increasingly important role internationally, not only because we are seeing increasing convergence, and that's very good to facilitate trade, cooperation between public authorities, but also privacy as a more, I would say, strategic element of a number of policies. So that's, I guess, what I can say very briefly on the report. You just have to wait 1 week, and in 1 week time, at this time, you will be reading our report.
Thank you so much, Bruno. And I want to give Helen a chance to weigh in because you mentioned that next week, the Irish DPC is going to publish something. And this is something that Helen mentioned in the keynote yesterday. And, just a chance to react, or if you want to weigh in, Helen, or maybe answer the question of, should we, review the GDPR and update it, and in what way?
So I'm glad Bruno reminded me that perhaps I misspoke yesterday when I said the Irish DPC was publishing a review, and I made it sound like the Irish were going to publish a competing review to the EU Commission's. Really what it is an activity report of 2 years of implementation of the GDPR on the part of the Irish DPC, of output and impacts insofar as we can measure them after 2 years. So it's really a progress and an activity report rather than an attempt to replicate or in any way contradict any analysis that the EU Commission may be doing at a broader level in terms of the impact. But I fully agree with the latter point that Bruno made. The GDPR is complex, and while some of the detail is not relevant to external stakeholders, but the complexities of the one-stop and what's been created there is perhaps having unintended consequences in the way that we're implementing it that are actually leaching resources of DPAs without delivering the benefit of harmonization, which some of the measures were aimed at. So I think there are some fixes that can be made without changing the legislation in terms of how the EDPB and the authorities operate. Look, it's a whole topic that you need to spend a day on. So thanks for the chance to comment, but I should probably stop there.
If I may add something, equaling an evaluation, we can use the term we want. Saying that this is not about reviewing the legislation does not mean, and here I fully agree with Ellen, that there are not a number of measures and actions that can be taken to address some challenges or achieve some improvements, and that will also be very much in our report. Us as Commission have certain powers, the EDPB and the DPAs, in terms of improving the functioning of some aspects of their cooperation, using some tools can also play a very important role. There are some co-regulatory tools to be developed with industry. All this will be also mentioned, and some of these tools will be identified as things we want to really focus on and work on in the coming months and years. So this is not just a sort of a snapshot, a static snapshot. We are also looking at what comes next and what are the tools we can use.
Thank you so much for specifying that. And now I will turn to Simon. And I also see two questions coming in. One of them about contact tracing. We might go back to contact tracing if we have time at the end. The other one about the role of the DPO in the application of the GDPR, and how can the role of the DPO be supported. And I'm going to link that to the question that I originally planned for you, Simon, which was, how has the GDPR been affecting the technology and innovation sector of the ICO? And what I actually have in mind with that question is the kind of innovations that we've seen out of the ICO, like sandboxing. I think that was something that that was well received. But I would like to hear from you about that. And if you can say anything also about DPOs and how DPAs can support the role of DPO within organizations.
Yeah, and it's I saw the question come up, and I think the question was well made, because the GDPR is structured, and I think this is a feature rather than a bug, but it is structured so that it asks data protection authorities to both be enforcers and to be advisors. And one of the ongoing challenges for any data protection authority is to understand how to both engage and advise and educate and lead organizations, and also reserve the right and have the discretion to intervene and execute on regulatory action and sometimes investigate and enforce. And it's hard sometimes to do both roles, and sometimes it's hard to move from one role to the other. And I think every data protection authority has to manage that journey sometimes, and that does really and Gary, to your question there about the role of the data protection officer, I think that's very critical there, because some of you know, in my old life before I joined the ICO, I was also on the board of the IAVP, and I'm passionate about the community of data protection officers out there. I think they are possibly the most vital community around the world for promoting data protection, far more important than data protection authorities, because we have between us all gathered together a few hundred staff across all the data protection authorities in the world, when there are many, many, many thousands of data protection officers in organizations who are fighting the good fight day in, day out. And I think it's very important that we find ways to support them and help them basically promote good practice and data protection compliance, because in doing so, we multiply anything that a data protection authority can do. The DPA can only have so many education advisory initiatives, or indeed enforcement initiatives at one time. So promoting good practice is critical, and yes, sometimes some more cases along the way would doubtless help DPOs rattle their sabers, but actually supporting data protection officers as a community and providing more advice and guidance is just as important. I'd say more important, and that is very, very relevant to the work that I'm doing at the ICO and many other regulators doing around the world on technology and innovation. I think that the work we've done has moved on a huge amount in the year and a half that I've been involved at the ICO. So you mentioned the Sandbox Initiative. We're now quite a way through that. So for members of the audience who aren't familiar with this, there's a regulatory sandbox is, and this cuts across many regulatory sectors, especially within financial services. It is a scheme whereby different organisations that want to do something interesting and innovative apply to work closely with the regulator to understand how they can do that in a compliant fashion. I think one of the key things to stress there is that we're not doing at the ICO, and we don't have the flexibility or functionality to do at the ICO. We're not providing regulatory waivers. We're not bending rules or providing exemptions here. But what we are doing is working very closely with a small number of organisations in how they can do, the work that they're doing in a more innovative way. So, for instance, there's a firm called Onfido, which is doing a lot of really interesting work around COVID, actually, and does work in terms of online remote verification, identification, and the like. And they're working through our sandbox and how they can try and remove bias from their AI for their facial recognition, their algorithms around that, which obviously is an incredibly hot topic right now. And we've worked with them to see how they can do that. And one of the key things there, Gabriella, I think, with the schemes in our sandbox is that, is this beneficial to the UK economy? Well, yes, because we're encouraging innovation. Is it beneficial to the organisations that apply to be in the sandbox? Yes, because that they learn what they can do in a compliant fashion. They can take the fact they're working with the ICO to their stakeholders, to their investors, and saying we're working closely with the regulator on this, so we're working towards making sure that we have a compliant solution. But the greatest benefit actually comes back to the ICO as a regulator, because we learn from the organisations in the sandbox at a really detailed, granular level what is going on in innovation and how they are struggling with different aspects of understanding the GDPR, understanding how to comply. And so that's one of the key things I think about the work we're doing in the sandbox. It's not a luxury product for us, it's actually how we're staying ahead of the game. And work we've done in there, we've got an organisation in the sandbox working on children's data, which that's directly influenced what we've drafted into our age-appropriate design code, for instance. We're taking learnings from one thing and putting it into another. So the sandbox is important to us, and that has helped inform the guidance we produce to data protection officers. We also have other initiatives going on in this world. So we have our Regulators Innovation Hub, where we have a team that works directly with other regulators in the UK on their projects to make sure that we incorporate data protection into sector regulation, because otherwise we are a horizontal regulator in a vertical regulatory world, and different organisations have to go to one regulator and then come to the data protection regulator. So we'll work with the Financial Conduct Authority, for instance, on how they, on their own sandbox at the FCA and their own tech sprints, which is their hackathons, on how they incorporate AML issues, anti-money laundering, into questions around privacy and bank data sharing. So how does that all kind of come together? And that enables a much more integrated approach to regulation. We've also done a lot of work in the last year on artificial intelligence. So we've produced guidance on explainable AI. We're about to release our artificial intelligence audit framework, talking about best practice in building controls into AI projects. And I chair the Regulators and AI Working Group, which has over 20 UK regulators from different sectors on board, sharing information and insight into how AI is affecting their sectors and working together. And one of the initiatives that's coming out of that, Gabriella, is work to develop a more integrated and perhaps in the end a shared data science capability between different regulators in the UK. We've realised that in terms of competing for data scientists, we are never going to be able to obviously outspend the large technology firms in the area of data science, and we are going to struggle to have our own individual data science teams across every individual UK regulator. But there is leeway to have a shared capacity which different regulators can draw down on, and we can have a team of experts that we can then all draw down on and share expertise and bring data scientists into our projects. So we're looking at how we have shared capacity as well as have our own in-house teams. And that's something we spun out of just the Regulators and AI Working Group. So those are some of the things that we're working towards. One last point I'd make, which talks to one of Helen's very first points, we had a listening tour last year where we went and spoke to different stakeholders in the innovation space, including a number of the VC firms, as well as startups, as well as some of the other innovation hubs within the UK. And we learned a huge amount from talking to those communities, and that's something we're going to integrate into the next phase of our innovation program. And I think it's really important that data protection authorities don't just talk to policy people and lawyers and consultants and other DPAs, but we go out and talk to different sectors, and we talk to investors and innovators. They have a very different perspective on life. They are not anti-regulation. Very often they are very keen to understand regulation and de-risk it from how they make their decisions. But often they haven't really been engaged with by regulators. And we learned a huge amount from that program last year, which we're now integrating into the next phase of our work. So I'd encourage everybody to keep those lines of dialogue going between regulators and these different communities. Anyway, I'll pause there. I've spoken too long, Gabriella, but that's where we are on technology innovation.
Thank you so much, Simon. And we have just a small amount of time to go to the next big topic that we prepared for today, and we promised the participants they'll hear about. But before that, and I just want to make a small comment about the UK, the GDPR and Brexit. Just my 2 cents, regardless of how Brexit goes in or what happens, of what the transition period or any of that. I would like to point the audience to the fact that the UK has adopted the UK Data Protection Act, I think in 1984. So my 2 cents, and this is just a comment from me, abusing my moderator hat, that the data protection is not going to go away from the UK. And then, of course, there are a lot of technicalities, and there's a lot of negotiation that needs to take place, and we are not yet at the point where we can give a lot of clarity about those situations. But just think about the fact that the UK adopted the UK Data Protection Act before, in those first countries that adopted data protection laws before the European Union agreed on Directive 95. So that was just me. I'm not going to open this Pandora box, and I'm going to go now to the last topic we prepared for today, and that's the Schrems II case. And I will invite Helen to weigh in and look into the magic ball, or how do they call it, and tell us what does she think the outcome will be.
Well, Gabriella, I don't have a crystal ball, and also really I have not been in contact with any of the judges on the Court of Justice of the European Union, so I have no particular insight. But I did attend the hearing in Luxembourg in relation to this case last July. So I think my big prediction is, based on hearing the Advocate General, or rather the Judge Rapporteur and the President of the Court of Justice of the European Union at the hearing, my big expectation is that they're going to deal very comprehensively with the issues, and that we're going to get clarity and answers to questions that have been long-standing in terms of the issue of data transfers, in particular to the USA as a jurisdiction. So that's my big prediction, that there's not going to be an element of kicking to touch about it, that certainly their intention, based on what they expressed on the hearing, was that it would be comprehensive. The other thing I suppose I want to mention is I would recommend to anyone who's interested in this topic that they look up the European academic Chris Cooner's blog. It's a very short blog. It's only a page or two long. If you put into your search engine Chris Cooner Advocate General opinion on SCCs, you'll find it on his europeanlawblog.eu. But in a short page, basically, he goes through the Advocate General's opinion, gives something of a critique, including pointing out a certain lack of logic, I suppose, to the ultimate conclusion of the Advocate General that SCCs should not be invalidated despite his earlier analysis. And of course, the Advocate General decided that the Privacy Shield shouldn't be looked at by the court in this context. So look up Chris Cooner's blog. It's a good way for all of us to set ourselves up for the 16th of July in terms of what the big questions at issue are. But certainly, I will be disappointed if there isn't much more clarity brought to the issues that have been circling around now for too many years.
Thank you for that. I will turn to Bruno now. Do you think that the court will follow the Advocate General and not weigh in into the Privacy Shield? Or how are you foreseeing things to develop with the judgment?
Well, making, for the reason that Helen has explained, making predictions, speculation is very difficult, also because the range of possibilities is very broad. You know, sometimes you're in litigation, it's A or B. Here it can be A, B, C, D, E, F, and so on, because it could impact the shield, could impact the standard control clauses, it could impact both, it could impact transfers, the standard for transfers in general, or it could have no impact. It could impact transfers to the US specifically, or it can have a much more global reach and indeed sort of clarify what are the standards for transfer of data for the EU in general, regardless of the destination, etc. So that's why it is so difficult. I would be surprised a bit in light of what Helen has already explained, but also because the court has been provided with all possible arguments. This is an informed litigation. You had us as the Commission, of course, who defended the decision we adopted, both the Privacy Shield and the standard control clauses. You had member states, you had civil society, you had the US. First time the US intervened in a litigation before the Court of Justice, a trade association, the EDPB. So nobody, some will like the judgment, some will like less the judgment, but nobody will be able to complain that the arguments, all the arguments have not been put forward, and the questions asked by the court show that too. The fact that they're also taking some time, which I think shows that this is an important and a complex issue. The fact also that this comes at the moment where there are other cases before the court which concern the same issues but in a different context. One concerns the UK, one concerns law enforcement / national security programs of some of our member states. So if we look at all of this and we try to put all of this together, and of course speculating, I would be quite surprised if at least the court doesn't clarify certain aspects concerning the application of the principles of proportionality, necessity, availability of the type of judicial redress, maybe that, or redress that one can expect. That there might be some clarification at that, I would say, quite a high level principle, and then we would see whether the court itself will apply it to one or several of the transfer tools that are being that are at issue in this case.
Thank you so much. This has been a fantastic talk. I think we could have gone on for another hour at least, and we have a couple of questions here in the Q&A, and the Wirewell team is saving all the questions and distributing them to the panelists. So you might hear back. Sorry for not being able to pick up all of them. Now, thank you to my fellow panelists. This has been fantastic and always a pleasure to talk to you.
Gabriella, first of all, I was listening the whole time. It's just a wonderful discussion, and it brought a level of depth to the whole community that I think is very important, especially in these times where we can't see each other quite so often. So on behalf of our whole Wirewheel team, I just wanted to thank you, Gabriella, Helen, Bruno, Simon, for participating. It was just very, very thoughtful discussion, and we'll look forward to having you back for Spokes 2021 when we have that as well. For everybody who's participating, and we had obviously a wonderful audience and a lot of participation as well, we will be recording and making these available for folks for free as well. We are saving all of the questions, so we will pass them on and figure out if there's a good way we can communicate answers if we can. Our next session is starting in 3 minutes. It's our national security panel. You can find the link in the agenda. The innovation revolution, the explosion of data, and what it means for national security and privacy. The panel is led by Charlie Savage from the New York Times. And the panelists are Bob Litt. Bruno and I spent a lot of time with Bob. He's just a wonderful expert. Yeah. From previously from the Officer of Director of National Intelligence, and now from Morrison and Foerster. Glenn Gerstel, now from the Center for Strategic and International Studies, and Jeremy Bash from Beacon Global Strategies. And it'll be a really thoughtful conversation. A lot of the things they'll be talking about obviously are very relevant to Schrems and the national collection issues that are on the minds, I know, in Ireland and the UK and in Europe as well. So look forward to seeing you in the next sessions. Thank you everybody for participating in this one, and thanks again for joining at Spokes.